Okay, good afternoon. It is officially afternoon. I want to welcome you to the EEOC. My name is Jolinda Johnson. I'm the Director of Training and Outreach for EEOC, and we are happy to bring you yet another informational brown bag session. Today's session is, what's the difference between the EEOC and the MSPB? We get that question a lot at the EEOC. I think probably our colleagues at the MSPB get that question a fair amount, and we thought it would be, this is a good opportunity to bring the two agencies together and talk about, at the same time, on the same page, talk about what each agency does, what the roles of each agency are, and how we work together and how we work differently. Questions come up quite often about why doesn't one agency do this when the other agency does, and there are good reasons for that. So I invite you to keep our panel busy. Ask them lots of questions. We don't have any handouts. We don't have any written materials. As is our custom with our brown bag events, these are informal events. They're opportunities for you to come forward and ask questions. So please do. I'm going to ask each panel member to introduce themselves and give a quick 3 to 5 minutes on what they're going to talk about and their mission statements in life. I've asked them to provide you as well. The one housekeeping note everyone needs to keep in mind, and I will yell at you and remind you forcefully during the session, is it is being recorded, so we need everyone, if you have a question, to use a mic to ask the question so that it can be picked up by the recording. We post these brown bag events on our website for use by those who couldn't be here in person. So in order that everyone can participate fully, please use the mics. With that, I'm going to start here and ask Mike to introduce himself to the audience.
Good afternoon, everyone. I am Michael Bogdano. I tried to be somebody else, but it didn't work. So you're stuck with me. I am from the Merit Systems Protection Board, and what I am here to talk to you about today is basically just going to give you a bit of a background on, okay, excuse me. I guess there's some problem with the microphones picking this up. Normally people can hear what I have to say even without a microphone. It's just that they prefer that they hadn't. But this time, I guess, you know, you're paying the fare, so I guess I should do this. What I'm here to talk to, spend a few minutes talking about is the jurisdiction of the board, excuse me, and what it's all about, what the board's mission is, and the kinds of cases that we can hear, because I know there's a large amount of concern over what it is that MSPB can hear so that people will know whether they have a mixed case or not. Personally, I am in what is known as the Office of Regional Operations. We have control over, to the extent that anyone can control other people, we have control over the regional offices of the agency. So we try and keep those folks in line and help them out. When you hear of a case coming to the board, except for our original jurisdiction, all of the cases go to our field and regional offices, and we have oversight over those offices. We also run the board's mediation program, and that's what I'm about. And so I will turn it over to Ray.
Okay, thanks, Michael. I'm Ray Angelo. I work with the Merit Systems Protection Board. I'm in what they call the Office of Appeals Counsel at the board. So after one of the administrative judges that Michael's office tries so desperately to control issues an initial decision, if either party disagrees with that decision, they have a right to petition for review to ask the full board, the presidentially appointed board members, to review the judge's decision. And that's what we do in the Office of Appeals Counsel. I supervise a team of attorneys, currently 6 attorneys, who do the day-to-day line work of reading a petition for review and deciding whether or not the judge's decision was correct, and then formulating a recommendation to the 3 board members who ultimately will decide the case. So if there's a decision of the board that you don't like, don't blame me, blame them. We give them our best honest recommendation, and hopefully they follow it, but they certainly aren't shy about letting us know when they would prefer to go in a different direction. What I'm going to follow up on after Mike kind of gives an overview of the board, I'm going to talk about a couple very specific cases that have come out in the last few months that provide some insight as to how the interplay between the board and the EEOC and the mixed case forum works. So that's what I'm all about.
Thanks, Ray.
Good afternoon. My name is Alexis Howard, and I'm an appellate attorney in the Office of Federal Operations. As most of you know, the Office of Federal Operations is the stage of the administrative process, typically where an aggrieved person is approaching the end of the process. Once the hearing has been conducted, once the final agency decision has been issued, then we are the attorneys who review those decisions and either determine if the procedural dismissal was correct or if the finding of discrimination or no discrimination is correct. At one time, I did work on mixed cases in my office, and I do a lot of the training for mixed cases in terms of the counselor training. We have a component there, and a couple of times I've done it for an agency request just to have an hour or two question and answer on mixed cases. So today, luckily we have the MSPB actually here, because a lot of times the questions are actually about the employee's standing or what actions are appealable, and sometimes I can't answer those questions because they are so specific to the MSPB. However, I will try to answer all of your questions about what happens when it gets to the EEOC. Thank you.
Thanks a lot. Thank you.
Hello, my name is Larry Green, and I'm a supervisory attorney in the Office of Federal Operations. I work in what's called the Review Division, and the group of attorneys that I supervise, we are the ones who write decisions on petitions of review that come from the Merit Systems Protection Board. So when we get a decision, basically we're either going to deny consideration, concur with what the MSPB has decided, or remand for more information, excuse me, or in a rare situation differ from the MSPB decision. So that's the section that I work in, and I supervise those attorneys.
Okay, so as each of our panelists mentioned, and I just want to remind everyone of what our format's going to be. They're going to give a brief overview from their perspective and talk about some specific things, but the bulk of the time has been allotted for your questions. So please don't be shy, and please use the mics. And with that, I'll turn it over to Mike. Thank you.
Hello again. The subject that I wanted to start out with talking about is just board jurisdiction. All of the board's non-mixed case decisions are reviewed by the Court of Appeals for the Federal Circuit. And the Court of Appeals for the Federal Circuit is famous for saying that the board's jurisdiction is not plenary. What that means in non-lawyer talk is that we cannot take jurisdiction over anything that we do not have jurisdiction over, either by law, an act of Congress has given us jurisdiction, or by regulation that was issued by the Office of Personnel Management. Those are the only ways that we get jurisdiction. We may want to take jurisdiction over certain things, but we have to live within those confines. The way the board works is that there are two forms of jurisdiction that we have: original jurisdiction and appellate jurisdiction. Our original jurisdiction is really not terribly relevant for these purposes. It mostly relates to cases brought by the Office of Special Counsel before the board. Those go directly to the board. They can involve the Hatch Act. They can involve corrective and disciplinary actions against, decision-making officials and what have you. But for the most part, what you guys would be interested in is known as our appellate jurisdiction, because what we review is basically an agency's decision. The most common decision that we review is an adverse action. Adverse actions, of course, are removal demotion, suspension for more than 14 days, reduction in pay, a reduction in grade, and a furlough for fewer than 30 days. Those are subject to 5 U.S.C. 7511, which is the section of the United States Code that defines who is an employee, quote unquote, for purposes of appealing to the board. That section of the code is probably the one that has created more casework than pretty much anything else when it comes to adverse actions. I won't bore you by reading through it, but if you have an adverse action and there's an appellant, an employee sitting in front of you who says, can I go to the MSPB? That's the section of the law you need to apply to determine whether he holds one of those kinds of appointments or meets one of those requirements for purposes of filing an appeal. Again, it's a question of simply fitting yourself in among there are 6 ways that one can be an employee depending on whether you're in the competitive service, whether you're in the accepted service and a veteran, or in the accepted service and a non-veteran. And each of those has requirements that get you before the board, but that's the first thing that you have to prove to us when you come to the board, is that we have authority to hear your case. Otherwise, it gets dismissed. Excuse me, the thing about adverse action jurisdiction in 7511 is that those requirements don't necessarily apply to all of the other kinds of appeals that we can hear. If you bring a RIF before the board and a reduction in force, it doesn't matter whether you meet the requirements for being an employee under the standards of adverse action. If you bring a suitability case or a restoration to duty or any of those, that is simply not the test, and those tests are set out in the regulations related to each one of those subject matters. So there's going to be a certain amount of confusion about the topics of who can appeal what, because not only do we have to have jurisdiction over the kind of action, we have to have jurisdiction over the person who brings the appeal of that action. So that is the first basis for confusion before the board. And as I say, really the only way in which to know whether you have an appeal right is to look at OPM's regulations concerning the particular kind of appeal that you want to bring. The cases that we get are almost all based on an agency decision, as I said, because that's where we get appellate jurisdiction to review those. The example in those cases, I should say, an appellant can bring an appeal not just from the action itself, but they can also raise one of 3 affirmative defenses that the law gives them. Number 1 is there was harmful error, which the board defines as error which, if it were cured or if it hadn't happened in the first place, would have led to a different result. The second one is that the appellant alleges that the action was not in accordance with law. That's a very rare kind of thing. What it means is that there was no basis in law to take this action at all. And then the third one is the one that perhaps gets of most interest to you folks, which is that you can prove that, if you can prove that your removal, suspension, whatever, was the result of a prohibited personnel practice, then we can hear that claim too. And of course, the big prohibited personnel practices that we hear are 5 U.S.C. 2302b1, which is discrimination, B8, which is reprisal for whistleblowing, and B9, which is reprisal for EEO activities and other sorts of activities. But B1 is of course, the issue of most interest for you all. We do not have jurisdiction to enforce the rules against the prohibited personnel practices unless they are brought in connection with an otherwise appealable matter. So if somebody comes in and says, I don't like the way the agency did X, and it constitutes a prohibited personnel practice, unless X is an appealable, something that's appealable to the board, unfortunately, we can't hear it. The other thing that you often hear about is the merit systems principles. Those two are not enforceable directly by the board. We don't get jurisdiction to enforce those unless there's another law, rule, or regulation that allows us to do that. The merit systems principles are in the section that comes in the code just before the prohibited personnel practices, and what those are is Congress's sort of kumbaya list of here's how the government should function. You know, everybody should do good, and everybody should be a hard worker, and all this good stuff. But while we try to write decisions that reinforce those ideals, we don't have the authority to simply enforce them on our own. And those are the two areas that I think confuse people consistently, the PPPs and the merit systems principles. Now, to confuse you even more, because that's what they teach you to do in law school. If people didn't need lawyers, you know, they wouldn't have law schools, and so law schools have this vested interest in making sure you go out and do harm. No, that's just the way it works. Is unfortunately the law is somewhat confusing on these kinds of issues, but in addition to the appellate jurisdiction that we have because an agency has taken a specifically appealable action, there are three kinds of cases that an appellant can bring where there is no clearly appealable matter. One is an IRA appeal, an individual right of action, in which the appellant claims something happened to him as a result of whistleblowing. And as I said, that's a PPP, so if that something that happened to him is I was fired because I blew the whistle, we can hear that as an affirmative defense. But if there is no appealable action, we can also hear a claim of whistleblowing standing on its own. We can also hear a claim under the VOA, Veterans Employment Opportunities Act, which is basically, I mean, there are several incarnations of it, but basically what it means is that the agency violated a veteran's preference rule or regulation to the harm of the appellant. And number three is we can hear a separate claim under USERRA, the Uniform Services Employment and Reemployment Rights Act. That is basically a claim that a veteran, or almost always a veteran, although it doesn't entirely have to be, was discriminated against on the basis of their military service. With those three kinds of cases, we can't hear affirmative defenses. So if somebody comes in and says, not only did they discriminate against me because of my military service, they also discriminated against me because of one of the Title VII reasons, we cannot hear that as an affirmative defense. So it's only in those cases that are actually appealable to the board, other than USERRA, VOA, and IRAs, that we can hear discrimination. But what all of that boils down to is that we do hear about 6,500 to 7,000 cases a year out there in the regions. We have about 58 AJs, and so they're pretty busy folk, but the average processing time in the regions is about 90 days. So cases don't simply languish at the board. The judges do a heck of a job in shepherding people through the process, and the process is what you would sort of expect at a district court or in any kind of proceeding, not tremendously different from the EEOC's. The board has the advantage that when an agency takes an appealable action, it's required to give its employee notice that they have a right of appeal to the board, and it's required to give them either a copy of the board's regulations or access to those regulations. And so that gets the ball rolling. People file appeals. We have an electronic appeals form. We have a paper appeals form. People can do either of those. The AJ then assigned to the case develops the record with the parties. There's a right to discovery. There's a right to subpoena witnesses and documents and things. The case record gets developed in pre-hearing conferences. Judges issue orders to make sure that the correct evidence comes in. And if there is jurisdiction, there's the right to a hearing in almost all cases. And before the board, unlike the EEOC, hearings are public. So you can very easily get either members of the press or just members of the public sitting in on a board hearing. What that leads to is the issuance of an initial decision. The judge covers all of the law and all of the facts and then tells the parties which way he or she has ruled. As Ray mentioned, if one of the parties doesn't like the board's decision, they can go to the board members and seek in a petition for review, seek the opposite result. Once the board issues its decision in a non-mixed case, all of our cases can go to the Federal Circuit, the U.S. Court of Appeals for the Federal Circuit. That is like one level below the Supreme Court, and we've had about a dozen cases over the years of the boards that actually have gone up to the Supreme Court, and the board has done very well. Indeed, our record before the Federal Circuit is about 95% affirmances, and before the Supreme Court, we're just about at 100% there, actually. So we're justly proud, I think, of the law that the board writes. That is basically the process, and I will turn it over to Ray.
Okay. Thanks, Michael. I'm going to just quickly talk about a couple cases that have come out very recently that I think illustrate the issues of dealing with discrimination law. The first one before the board, and the second one was actually decided by the Court of Appeals for the Federal Circuit, one of those cases that somebody appealed to the Federal Circuit from the board. The case I want to talk about is called Sutherland versus Department of Defense, and this can be found on the board's website. I don't believe it has a Westlaw citation yet, but the board's website is actually a very useful source of information, www.mspb.gov. You can get all the board's latest and greatest decisions the same day they're issued. I know you'll all stay in the office Friday night late just to get those. But Sutherland is 2011 MSPB 92, and it was issued October 5th, 2011. Mr. Sutherland worked for the Department of Defense. He was some sort of distribution worker, and this required him to do some heavy lifting from time to time. He suffered an on-the-job injury, and upon his return to work, he told the agency that he had a 10-pound lifting restriction. The agency accommodated this for some time and asked him for medical documentation to support this. This relationship went on for some time. The agency would ask for information. He would provide stuff. They would say this isn't adequate. This went on. Finally, the agency suspended him for insubordination for his failure to provide the medical documentation. And then after that suspension, he continued his behavior. They ultimately removed him for failing to provide the information, charging him with insubordination. Following a hearing before one of the board's administrative judges that Michael spoke about, the judge reversed the action, finding that the insubordination requires a willful and intentional refusal to obey instructions, and the agency here wasn't able to prove that. The AJ did sustain a couple lesser charges, said they were worth a letter of counseling, and we're really not going to worry about those any further. Now, regarding Mr. Sutherland's disability discrimination claim, and that's why we're all here, the administrative judge found that he was a qualified individual with a disability, that the deciding official considered his disability when making his decision, and that the agency would not have taken the same action in the absence of impermissible discriminatory motive. The agency, not happy with this decision, filed a request for review with the full board. The first thing the board did is it noted that there was some contradictory evidence regarding Mr. Sutherland's efforts to get medical documentation from his doctor. And so the board said that the judge didn't properly resolve those issues, and it vacated the judge's decision in that regard and sent it back, remanded it back for the judge to take more evidence and make further findings of fact. But what we care about is what they did with the discrimination issues. The board found, and I'm going to apologize, I want to be careful on how I say these things, so I may do a little reading here. The board found that the administrative judge improperly analyzed Mr. Sutherland's disability discrimination claim. They noted that the ADAA, the amendments in 2008, liberalized the definition of a disability, and they applied to this case. Now, to the judge's defense, at the time that he issued his initial decision, the EEOC had not yet promulgated its May 24th, 2011 regulations implementing the statutory change, nor did he have the benefit of the appendix to Part 1630, which also helps understand how the analysis to take place. So the board acknowledged that, but then went forth and set forth that the ADAA definition of a disability and found that consistent with the regulations, because Mr. Sutherland maintains that the agency removed him on the basis of his impairment as compared to a reasonable accommodation claim, the judge's analysis should have focused on whether he was subjected to a prohibited action because of an actual or perceived physical or mental impairment, regardless of whether or not that impairment substantially limited or was perceived to substantially limit a major life activity. The board further explained, again, consistent with the EEOC's new regulations, and that's really what this case boils down to, was kind of the board following the EEOC's new regulations. But the board found that establishing an individual is regarded as having an impairment isn't the end of the analysis. It doesn't establish agency liability. Liability will exist only if the individual proves discrimination on the basis of his disability. So the board sent it back to the administrative judge and said, take a look at the EEOC's new regulations, take a look at the appendix to 1630, and take another shot at the initial decision. Now, the other thing that the board said here, it looked at the question of whether a mixed motive analysis should apply to discrimination claims of this nature. And the board looked at some recent Supreme Court decisions and a Seventh Circuit decision and noted that they've called into question whether the mixed motive analysis is appropriate. And what the board concluded is that in enacting the 2008 amendments to the ADA, Congress did not intend to authorize mixed motive analysis to a disability discrimination claim. Thus, it was the appellant who ultimately has to prove by preponderant evidence that their employing agency took an action on the basis of the disability. It remains the appellant's burden. Say Sutherland just came out a little over a month ago, so it kind of represents the board's latest and greatest thinking on interpreting the EEOC's regulations on the ADAA. The other case, and I realize we're running a little long here, so I'll just quickly mention this other case. It was called Diggs versus Department of Housing and Urban Development. And this is a Federal Circuit decision. It's Federal Circuit number 2010-3193, and it was issued on November 1st, 2011. Ms. Diggs was removed for her position. She appealed to the board. She alleged before the board that the agency action was in reprisal for her prior EEO complaint of sex discrimination. The board AJ affirmed and found that she failed to prove her discrimination allegations. She then came to the EEOC. The EEOC said, yeah, you haven't proven it. She then files with the Court of Appeals for the Federal Circuit. And the court notes that it lacks jurisdiction over mixed cases. You can't take a mixed case from the MSPB to the Court of Appeals for the Federal Circuit. But the court noted there's a question regarding whether an allegation of reprisal for prior EEO activity was a sort of discrimination claim under Title VII that would put the matter outside the court's jurisdiction. And after discussing decisions from the Supreme Court and its sister circuits, the Federal Circuit held that a claim of retaliation for prior EEO activity is in fact a discrimination claim prohibited by Section 717 of the Civil Rights Act, and therefore Ms. Diggs's case presented a mixed case, and that put it outside the jurisdiction of the Court of Appeals for the Federal Circuit. As an agency, you're probably thinking that's one of the few times when you actually want a mixed case. If you're going before the Federal Circuit, it's one of the few times you're going to want to do that. So Mike and I have taken up a good chunk of time, I think longer than we were supposed to, so I'll pass it along.
Okay, really quickly, just to let you know where we pick up in terms of the EEO administrative process. Once a counselor, I don't know what everyone's position is here, but just assuming that the counselor has informed and agreed that the matter might be mixed, the employee then has the right to elect which process to proceed in. They can either go with a mixed case complaint or a mixed case appeal. And the mixed case complaint, for intended purposes, is essentially similar to a regular discrimination complaint in terms of that the employee is going to file a mixed case complaint with the agency. The agency is going to conduct an investigation, but the investigation time is shorter. It's 120 days. The agency then issues a final agency decision within 45 days, and the employee has the right to appeal that to the MSPB, not the EEOC. After that stage, then they can then go forward to petition the EEOC, but we rarely get mixed case complaints. Usually the mixed matters that we see are actually mixed case appeals, which the mixed case appeals are, like Michael spoke of, there's an adverse action and the agency indicates in that decision or action that the employee has rights to the MSPB. The employee files a MSPB appeal. It's assigned to an MSPB administrative judge, and that judge may hold a hearing. Typically, when I processed MSPB matters that came before us, there was a hearing. I don't recall ever seeing an instance where there was not, where the MSPB determined that there was jurisdiction. The MSPB administrative judge issues an initial decision, as he indicated. That decision can then be petitioned for review with the full board, and then that decision can then be petitioned to the EEOC. And those are the matters that we typically see. It only gets a little hairy when you have an employee who then starts to do what we call dual filings, and they file an EEO complaint and a mixed case complaint and a mixed case appeal. Just to let you know, initiating EEO counseling is not an election to proceed in the EEO process. It's not until that person files a mixed case complaint or appeal that an election is made, and whichever is filed first is what we determine the election to be. I'll turn it over to Larry. I know you guys are going to have questions about dual filings, so I'll just wait to your questions.
The excuse me, the section of the regulations that deal with mixed case complaints and appeals can be found at 1614, 302 to 309, 29 CFR, excuse me. So that's the section that we deal with at the commission when we're deciding on how to process or proceed with a MSPB decision or mixed case decision. As I said earlier, my little slice of the world is kind of narrow. What we do in my section is when we receive a petition for review from an MSPB decision, what we do is to look at whether or not the MSPB got the discrimination part of that decision correct. And I guess what I mean by that is we could receive a decision that's sort of like 50 pages long, for example, and I'm making this up, you know, decisions aren't going to be that long.
God, I hope not.
But let's say on page 35 of the decision, they deal with the employee's discrimination claim, disability, race, sex, reprisal, what have you. And let's say in that decision, it's probably 5 pages that deals with that discrimination allegation. Well, that's our section, because there are other things that the board may have dealt with that have nothing to do with discrimination. So we're not going to say to the board, well, you got this analysis wrong, or you got it right, or whatever. We're only dealing with that narrow slice of discrimination. And as I said earlier, what we're doing, we're making several determinations. We can deny consideration. That happens in cases where the MSPB decision doesn't deal with discrimination, or it doesn't deal with an issue that we have jurisdiction over, such as veterans' rights and veterans' preferences. The commission doesn't have jurisdiction over that. So if a decision, if somebody, for example, filed in a petition for review with us, we would have to deny jurisdiction over that. There are other situations where that occurs also, where we are denying jurisdiction. We can concur. We could agree with them. We could say, well, yeah, you got it right. You found no Title VII violation. You found no disability discrimination, and you were right. We concur with that determination. We could remand for additional information. You might have a real complex case, and you know, in order for us to make a decision, we need additional information that the MSPB needs to go back and hold a hearing or whatever other method they might come up with to get that information for us. Provide us with that information, and then the matter comes back to us, and then we can issue a decision at that point. And as I said, in a very rare situation, we might differ with the MSPB and say, well, sorry, you guys got this wrong. There was discrimination in this case. And it has happened in the past. I think roughly probably about, I can think of only about 2 or 3 cases in the recent past where something like that has happened. But I'll wait your questions, your further questions.
Okay, so I'm going to open the floor up for questions. Again, if you want to ask a question, you need to use a mic. I can either hand it to you or you can come up to the stand mic. I'm going to start us off. I have a couple of questions for Michael. My first question is, what does pretty close to 100% mean? You said that the MSPB was pretty close to 100% before the Supreme Court. What does that mean?
Well, in those cases, what it means is that, in fact, the Federal Circuit had reversed the board, and the decision of the Supreme Court either reinstated the board's decision or said something very much akin to what the board said that reversed the Federal Circuit.
Okay, my second question for you is, you talked about 2302B1, 8, and 11, and I wanted to focus on B8, reprisal for whistleblowing. Can you talk to us about how your jurisdiction differs from the jurisdiction of OSC with regard to whistleblowing?
Okay. We can hear cases brought by the special counsel with whistleblower allegations. The special counsel can bring stays requests to the board. They can represent appellants before the board. But what we hear most frequently is other than, well, is the 2 things that I mentioned. Number 1 is we can hear a claim of, in reprisal for my whistleblowing, they fired me, and so that the appealable matter is the firing itself. But we can also hear a claim that something that is not normally appealable, I was not hired, I was not promoted, I was given, some other kind of assignment than what my normal duties are because of my whistleblowing. If people have gone first to the Office of Special Counsel, raised their claim with the Special Counsel, and the Special Counsel has found that they were not going to go further with it, they were not going to go investigating any further. So our jurisdictions are about the same with respect to the subject matter of what can be raised as a whistleblower claim, but it is the board that has, has the authority to actually order corrective action. Special counsel can work with an agency and ask it to take corrective action, but if the agency thumbs its nose at the special counsel, that's when special counsel comes to the board and raises the issue with us.
Okay, thank you. Questions?
Thank you. My question is for you, Michael. You mentioned two things that, if you could clarify. You mentioned some adverse actions categories where the MSPB does not look at the definition of an employee. And I think you said RIF, suitability, and restoration of duty. Did I get that right?
Yes. The adverse action is a term of art under the law, and it means specifically and only a removal, a suspension for more than 14 days, a demotion, a reduction in pay, a reduction in grade, or a furlough for fewer than 30 days. The other actions that I mentioned, reduction in force, suitability, restoration to duty, all of those are not considered, they are adverse to the employee probably, but they are not called adverse actions. They are separately appealable matters, and they have different jurisdictional requirements that are, generally speaking, looser than those for being an employee with adverse action appeal rights.
So an employee that's not covered under 5 U.S.C. 7511 could go before the board if any of those actions happen to him or her?
It's entirely likely that they could. There are requirements for each of those as well, but they are much less specific to the kind of job, the kind of appointment that the employee has.
Just one other clarification question. You talked about 3 kinds of cases an appellate can bring, but I don't know, IRA, VEOA, and USERRA. Could you clarify what is it about those that is distinguishable?
Well, the two things about IRA, USERRA, and VEOA that are distinguishable are that, number one, there is not a specifically appealable action taken by the agency that gives gives an absolute right to appeal. Rather, in those instances, the appellant makes an allegation that the agency did something that is appealable. The agency, of course, claims that it didn't, and therefore the appellant has to prove to us that, in fact, we have jurisdiction to hear these kinds of claims because they have, in fact, alleged that their veterans' preference rights were violated, or that, that whistleblowing was a contributing factor to their whatever action was taken against them, and also under USERRA that they were discriminated against because of their obligation to perform military service. So the first thing is that there's no specifically appealable action. The second thing is that when we get one of those appeals, we cannot hear any other affirmative defense, those 3 being harmful error, not in accordance with law, or prohibited personnel practice. So if the appellant brings one of those, he cannot say, not only was I retaliated against for whistleblowing, but it was also discrimination based on my, race, gender, whatever.
Okay, Alexis, I have a question for you. You were talking about dual filing. Sorry, I didn't mean to surprise you.
That's okay.
Could you elaborate a little on the dual filing issue? How far along, if I'm a complainant or a person who believes I've been discriminated against, how far along in the process can I go before it is considered an election? Is it just the filing of a formal complaint, or is it EEO counseling, or what?
It's the filing of the formal complaint, not the EEO counseling. Sorry. Actually, the election is made with the filing of the mixed case complaint and the filing of the mixed case appeal. At the counseling stage, you're just gathering information from the counselor, and at that time, the counselor should inform you based on what you have presented to him or her that this might be a mixed case matter, and inform you that there is an alternative process that you can go through. If you want me to talk about dual filings, I'll kind of have to read that because I really hate, just like Ray said, you don't want to misstate anything, and just one word can kind of throw it off. Would you like me to go over that? Okay. If an election is made, if the employee elects the MSPB forum by filing an MSPB appeal, and there is no dispute of the MSPB jurisdiction, the agency must inform the employee to inform the MSPB of their discrimination allegations. They must procedurally dismiss the EEO complaint pursuant to 29 CFR 1614.107A4, and of the ability to appeal the MSPB final decision to the EEOC regarding the discrimination aspect only. So, again, like Larry said, we only do the discrimination aspect. We don't deal with harmful error, Douglas factors, and all of that. We just do the affirmative defense of discrimination. If the employee elects the MSPB forum and there is uncertainty by the agency as to the MSPB jurisdiction, they must inform the employee that they'll hold the matter in abeyance pending a decision from the MSPB on jurisdiction, and they must inform the MSPB of any discrimination allegations. It's really important when the person files the appeal that they indicate on the MSPB appeal form that they're alleging an affirmative defense of discrimination. If the employee elects the EEO forum by filing a formal complaint first, then the agency should inform the MSPB of the existence of the mixed case complaint and ask them to dismiss the matter, the MSPB appeal, without prejudice. Basically meaning if for some reason the employee needs to go back to the MSPB, they're not prohibited because it was dismissed without prejudice. Do you agree?
Let's hope our MSPB colleagues agree with that.
Okay. If an MSPB judge decides that the MSPB has jurisdiction of appeal, the agency must dismiss the mixed case complaint that has been held in abeyance and advise the employee of the right to appeal the MSPB final decision on the discrimination aspect only to the EEOC. I think we only have a couple more. If the MSPB judge decides that the MSPB lacks jurisdiction of the mixed case appeal, the agency must treat the matter as non-mixed and inform the employee that he or she may contact an EEO counselor and file a formal complaint. And the employee has 45 days from issuance of the notice to contact an EEO counselor, and the date that they filed the mixed case appeal would be considered the date they initiated EEO contact. And similarly, if an employee files an MSPB appeal but does not file a mixed case complaint, and the MSPB finds that it lacks jurisdiction over the matter, the agency must inform the employee, again, of the right to contact an EEO counselor. If you need these notes, I think we can probably get a listing of all of the class participants and perhaps email them to them, because the dual filings can be very confusing, and that's why I wanted to read from my notes.
You may have. Okay, can you hear me now?
Yes.
You may have answered my question and,
Okay.
and all of that. I'm not sure. I just, as an agency rep, I can tell you fact pattern that we're seeing over and over again is an employee files a discrimination complaint with the agency, and it's being processed by the agency and investigated by the agency. And then during the course of that investigation, the employee resigns. And it becomes a mixed case because they amend their complaint to allege constructive termination. In the meantime, the agency hasn't issued the final agency decision in the 120-day period, and the employee files a constructive termination complaint with the MSPB. The MSPB requires the agency to respond to the jurisdictional issue. I'm just wondering, in the meantime, what is the agency to do with the processing of the EEO matter? Do they continue to process the FAD, or do they hold everything in abeyance until the MSPB rules on jurisdiction and in my experience, almost always accepts jurisdiction over the constructive termination claim, holds a hearing, and what happens to the EEO portion?
I would think that you would hold it in abeyance. Jolinda, you can let me know if you think something differently. But constructive discharge is interesting, and I want to defer to the MSPB on the constructive actions, because at one time, a long time ago, we used to get a lot of hostile work environment claims, and then there would be a resignation and the person would allege constructive discharge. Well, at one point, we used to say, or try to send it back to the MSPB, or say that they should have jurisdiction because it's inextricably intertwined or it's subsumed into the constructive discharge. However, we don't do that anymore because we can't tell the MSPB what their jurisdiction should be. So I'm going to defer to them if they don't mind. Michael and Ray.
Obviously, the board doesn't have any say over how an agency processes the EEO portion of the complaint. What we do have a say over, though, is whether we have jurisdiction over the constructive removal claim. We can hear claims where an appellant alleges that I should say we cannot hear claims over a voluntary action because voluntariness means that it wasn't in any way adverse to the employee. But if an appellant claims before the board that what looks like a voluntary action was in fact involuntary, it can end up being considered an adverse action. That happens where you have claims of I resigned or I retired because of coercion, duress that was brought on by the agency, because of intolerable working conditions, or because the agency was going to take an action against me that they knew could not be sustained. And so I resigned or retired in order to avoid that. We can also hear claims similarly to that regarding I requested a demotion in order to escape, intolerable working conditions, or I was absent from work and therefore constructively suspended because I couldn't bear any longer to go back to the office due to the agency's coercion, working conditions, what have you. And last of all, even with respect to a disability retirement, there are some situations in which an appellant can try to prove that there is jurisdiction over those claims. We will frequently hear a case, that is, hold a hearing in one of those cases, because the appellant's burden in getting a hearing is simply to make a non-frivolous allegation of fact. And a non-frivolous allegation basically means a claim which, if proven, would show that the board has jurisdiction. So we will hear those cases, but during the course of the hearing of the case, we will not decide the EEO issue. What we will do is look at the EEO claim only as far as it relates to the duress claim, the coercion claim, or the intolerable working conditions kind of claim, we will only look at it as a Title VII claim or an ADEA claim or ADAAA claim, whatever, if we find that we have jurisdiction. In the bulk of the cases, we don't find that we actually have jurisdiction over the claim, but we can if the facts are right. We will not, despite holding a hearing, the end result is we're going to dismiss the case for lack of jurisdiction if the appellant hasn't proven that, in fact, his action was involuntary. And then it is not a mixed case.
I guess I misspoke because I said that in most of the cases you're finding jurisdiction, whereas in most of the cases you're holding a hearing to determine jurisdiction.
Exactly.
So, do you ever see cases where on the pleadings the MSPB is finding lack of jurisdiction, meaning that the appellant didn't? I mean, I've seen appellants make almost no showing, and it's determined by the AJ to be a non-frivolous showing.
Yeah, there are cases in which we don't hold hearings. There are certainly very many of them. And it's just those that are the least likely to prove to be jurisdictional. I mean, if the appellant raises a claim that his working conditions were intolerable and the judge says, okay, what's your proof on that before we go to hearing? And he says, well, every day the boss walked in and he didn't say hello to me. He's not going to get a hearing because that, even if true, is not enough to prove that his working conditions were intolerable. Obviously, that's an extreme example, but we get some that are close to that. So that's, I mean, that does happen. But it is safer, certainly, to hold a hearing and get the evidence and then make the determination that we don't have jurisdiction than it is simply to dismiss for lack of lack of a non-frivolous allegation.
When the underlying basis of the constructive termination claim is all about discrimination, how do you parse those issues for purposes of staying with MSPB jurisdiction over the constructive termination, and then the discrimination issues are then going to be appealable to the EEOC? How is that parsed? It's never been clear to me how the MSPB separates the appealable issue from the discrimination issue.
Well, we look at the claims of discrimination as claims of coercion or claims of duress or claims of intolerable conditions. We simply don't, for instance, if an appellant says the thing that made this intolerable was the agency didn't treat me properly because of my disability, we don't look at first at whether the employee is a qualified individual with a disability. We don't look to determine whether the accommodation he requested was reasonable. We don't look at the finer points of the EEO action itself, the EEO claim itself. We will simply look and see, are these facts sufficient to support the claim that there was an intolerable working situation? And if we find that they are and that we have jurisdiction, then number one, the action gets reversed. The appellant's removal or retirement or resignation is reversed. And it's only at that point that we actually look at the niceties of the EEO complaint itself, the EEO requirements, I should say.
Yeah, I had a question actually about the previous example. We were talking about cases where there is an EEO investigation ongoing, and then you do get an amendment for constructive discharge, or we're also seeing a lot of proposed removals, which very much can be accepted as a claim of retaliation, meeting that test, meeting the lower burden, and then obviously that either becoming a removal action that could be appealable to the MSPB or the constructive discharge claim. And I'm trying to figure out, you had mentioned that this maybe lead to the idea that the EEO investigation would be held in abeyance. And I'm just maybe seeking a little bit more clarification as to that. I know that we'll see situations where someone will bring a proposed removal, for example, and that might be an accepted issue. And then we find out later that the person is removed, but hasn't filed necessarily a mixed case complaint with us or raised it with the agency's EEO office, but we have found either we have discovered through the investigation or found secondhand that they have in fact filed an MSPB appeal upon the MSPB appealable action. And so the way that I would see it is that maybe even though they were eventually terminated or there was a constructive discharge, they resigned, would that necessarily be a part of that original EEO investigation? Couldn't that investigation continue to be ongoing while this person has elected their MSPB rights and for that claim?
Well, I guess my question, I would have that, I'm starting to, sense from the two questions. Do you all think that there's a problem in holding the thing in abeyance while the MSPB decides on the constructive discharge claim? I mean, would that be a hardship, on the agency by doing that?
I mean, I think that I would have some concerns, especially evidentiary ones, where managers and supervisors retire every day or leave the agency every day, and it's common knowledge that obtaining affidavits from supervisors who have left the agency can be extremely burdensome, and so even waiting 3 to 6 months to do an investigation when it could be done now, could potentially be an issue. Likely it may not be, but we've certainly seen cases where there have been delays, and then ultimately the agency, is scrambling to meet its evidentiary burden because of those personnel issues that have occurred. So I would say that, at least from my personal view, there would be concerns about holding it in abeyance unless there was a very substantial reason to do so. We would prefer to investigate, in a much more timely fashion. So.
First of all, I had a question. The proposed removal would not state a claim. You said that you're accepting those for under reprisal, you said.
As a retaliation issue, for everything else, right, it wouldn't be.
Right, okay. I think that the determination to hold in abeyance is more of an opinion, but I think that's the best way to go because, as Michael said, in a lot of instances that they're going to find that the constructive discharge is not within their jurisdiction. What the person is probably trying to do is trying to use the actions that they allege prior to the constructive discharge to substantiate the constructive discharge. This is what happened to me, and this is why I end up leaving. Or are you alleging, just to kind of clarify your question before that she asked, the actions that you're alleging, was the person saying that those created a hostile work environment that then led to their constructive discharge, or they're needing to resign, or?
They're usually alleging that the discriminatory acts led to a hostile work environment that led to the involuntary resignation, yes. Right,
so if that matter came back to you, if they determined that there was no jurisdiction, then you would be able to investigate all of those together because they are the basis for the constructive discharge claim.
But that investigation is ongoing, and the agency was actually in the process of issuing a final decision. Does that investigation start anew after the MSPB determines that it doesn't have jurisdiction?
Michael, roughly how long does it take for you guys to would it take for y'all to get a decision back on the constructive discharge allegation?
Well, as I say, the average processing time in the regions is about 90 days. If one of the parties is not happy with the board's decision, they can file a petition for review. They have a 35-day period to do that, so you've just added on an extra month. And then, it can take the board, another 3 or 4 months or more to decide the cases.
But you said even 3 to 6 months delay would be a problem at the agency.
Yeah, because I mean, obviously, I would, not that no one else is concerned about timelines, but the timelines are very much a very high priority and principle within our office, meeting and trying to get as close to 100% on our regulatory timelines. But we also have had an adverse decision regarding our agency about a year ago in which we did an investigation, and it was within the timelines, but because one of the supervisors had left the agency and there was a difficulty, in that process, it did lead to reversal of the decision. And obviously, there's only so much you can do when people retire. But we've made a note that in our investigations that we should try to avoid any delay as far as soliciting those management affidavits, because we understand that these situations could arise, and that potentially that decision may have been different, if we were able to contact agency management, earlier than we had. We hadn't held that case in abeyance, but
Right.
it showed us what delay could do to an investigation. And
So if I understand correctly, the alternative would be to continue processing the other actions that create the hostile work environment and issue a final agency decision on that. And then if the MSPB determines that constructive discharge is not under their jurisdiction, then it would come back to you and you would file do a separate investigation on the constructive discharge? Or no? How is we want to make sure that we're preserving the employee's rights, so.
I think the constructive discharge drops out of it after the MSPB part of it. That's always been my understanding.
No.
That the agency's only investigating the pure discrimination claims.
But if the MSPB decides that they don't have jurisdiction over the constructive discharge, then the person it would go back to the agency then at that point to process. And so you would be advising the person on the constructive discharge claim at that point. And then they would go ahead and could conceivably go ahead and file a complaint on that. I mean, I have an interesting case now where the agency was arguing that because, even though the MSPB issued a decision finding no jurisdiction on the constructive discharge, the agency argued that because the decision was so detailed that it should be considered a finding on the merits. And the administrative judge in that case disagreed and went ahead and found discrimination. So it's not solely automatic that just that's going to be the case. It should, like I said, it should go back to the agency for them to counsel the person and process that claim.
We have a couple of questions pending, so I want to get to them. But before we leave this issue, I want to throw out a question to the panel that may help or may not help clarify this issue. There's nothing in our regs that state that the agency cannot go forward with their investigation yet hold the FAD in abeyance, therefore preserving all the evidence that is to be collected, but nonetheless respecting the board and waiting for their decision and then acting on that.
And the big thing would just to keep the employee apprised of what's going on, because if they don't issue their FAD within a certain time frame, then
they might request a hearing. So if you let the employee know that you are going to complete the investigation, but nonetheless hold a decision in abeyance for the MSPB, I want to make sure that I'm correct in stating I don't think there's anything in our regs that state that you cannot do that. And
I don't think it would be a
protect
problem.
all evidence that is to be collected and do so in a timely manner. Okay, so we have 1, 2, and then 3.
Alexis, MSPB indicated that they have about 58 AJs, and they hear their cases in 90 days. Can you can you mirror that? Can you mirror that those statistics for EEOC, please?
essentially they have almost double the number of attorneys that we have. I think we have about 30 attorneys at this time, approximately 30 attorneys.
In Office of Federal Operations.
In the Office of Federal Operations, working on appeals. procedural and merits. And at any given time, I think we probably have a couple of thousand of appeals in our inventory. I don't know what to say about that. Lawrence is a supervisory attorney, so maybe.
Larry, maybe if you could just expound. I knew this question was coming. Why does it take EEOC so long to get decisions out as compared to, I'll say it for you, it's okay. Why does it take the EEOC so long to get decisions out as compared to the MSPB? If you could just sort of expand on the jurisdictional differences and what that means for actual inventory. And just as a comparator, they have 58 AJs. The EEOC has roughly 100 AJs, but there is the appellate stage, which is a different matter.
Yeah, and I guess obviously the important thing too is that we can't really speak for our AJs in terms of the of their caseload or what have you. So I couldn't really tell you, you know, compare our AJs to their AJs. But you know, we get thousands of appeals each year, and unfortunately, we only have about, in the Office of Federal Operations, the appellate level, I mean, we only have approximately 30 writing attorneys at this point. So, you know, at any given time, you know, just being a supervisor, I mean, my people have caseloads of, you know, lots of cases, let me put it that way. They have lots of cases in their inventory. And each case has its own level of complexity. Some cases obviously are easier than others. Some cases have different levels of review than others. I mean, some cases that come in, I might be able to look at, sign off on, get it out just like that. Other cases have to go through other stages of review. So there are all kind of issues that might affect how long it takes for us to get a decision from the writing attorney into the complainant's hands that, you know, no case is the same, I guess is the best way that I can address that.
And also jurisdictionally, what the MSPB hears versus what the EEOC hears differs greatly.
That's true.
More narrow.
Yeah. Let me just add something to this. I'm Catherine McNamara, and I work in the appellate program as one of the managers. The jurisdiction for EEOC is very different, as Jolinda was saying. The MSPB has very discrete personnel actions that trigger their jurisdiction. Anything that happens to anybody can be an EEO complaint. And so you get a very broad range of things from, he looked at me funny, to, I was fired. And because you can complain about anything, and because it's a very accessible process, which is good, there are many more EEO complaints in the process than there are MSPB appeals, and that sort of filters up. At the appellate stage, we receive close to 5,000 appeals a year for the 30 attorneys to work on. And we are doing over half of our cases in less than 6 months. That may not seem that obvious to you, but it, you know, it's about 60% of the cases last year were done in less than 6 months. So I think that the difference in jurisdiction and a little bit the difference in staff is what affects the time frames.
Yeah. I'm just going to mention the board's appellate procedure. As Mike mentioned, we have about 58, 60 administrative judges. At the board level, writing the decisions for the board, we have 20 attorneys, and we deal with, again, a much smaller volume of cases. We're dealing with about 1,100 petitions for review each year. But I think in terms of our organizational structure, yes, some of those cases, you know, a staff attorney writes them, they come to me, I just say, yeah, that looks good, sign it, send it to the board members, and others bounce around the office for quite a while as, you know, the director and the deputy director all chime in and try to figure out what we want to recommend to the board. So it's, I think we have similar processes, and hopefully we can get similar results.
I have a question about mixed case complaints. Is there any time when a person elects to go with the MSPB, is there any time in a mixed case complaint that it goes back to the EEOC? If they elect to go MSPB, is there anytime the EEOC, well, I heard that EEOC looks at it on a mixed case appeal, but is there any circumstances under which a mixed case complaint, the complainant, would end up before the EEOC?
Well, after the final decision is issued and it goes to the MSPB for a hearing, it could come back to us on petition for review. So, you know, it would start with us and it could end with us when we're reviewing the MSPB's decision for the discrimination aspects.
Okay, new question. I hope I'm not repeating some of this, but this stuff is of course, very confusing. It would be nice, maybe, Alexis, to get your notes. You said you might have them for us.
Yeah, I assume when people registered, they had to provide an email address. Perhaps it can be sent out.
Yes, if you RSVP'd, then we can send them out. If you are not on the RSVP list, you're not on our registration list and therefore won't get them, so let us know.
Okay. Now, here's my question. It goes to, you mentioned inextricably linked is out. And I said, what? What happens? I'm going to give you a hypothetical. Counseling letter about performance improvement plan, and a removal for poor performance with MSPB appeal rights. So we got a complaint on all three allegations. The only one that's directly appealable to MSPB is the removal. Now that's a mixed case complaint. Now the other pieces, where do we divide them up into two cases? I mean, that's what we've been doing. We've been saying, well, we first look at it and say, well, it goes to the inextricably linked part. You get a performance letter. Supervisor says you're doing bad. Then they give you a performance improvement plan related, and they mention the letter. Those are connected. Then they remove you because you do bad in your PIP. They're all hooked together, but we can't give something to MSPB. I know that old EEO bulletin. Right. What do we do? I mean, is that, for instance, is that two cases? Is it one case? I mean, this stuff is just a mess. I mean, how do we do it?
What would you mean? Like I said, we don't do the inextricably intertwined anymore. I think we use subsumed now, but when you have things that are so varied, like you said, a performance improvement period, and then I think you mentioned a removal, a letter. It seems that the removal is not going to come back because they have jurisdiction. It seems like, would you think that they should be processed separately? It seems like it's so varied, and that the performance improvement period, that's a good question. I'm trying to think it out. But they could argue that the performance improvement period was a part of the removal because it led to the removal, but I don't know necessarily I don't think that the MSPB would think that fell in the jurisdiction.
But it's totally an EEOC case at this point.
Right,
I mean,
right.
I'm saying there's no MSPB appeal.
At all,
It's
okay.
all in a complaint.
Okay.
So it's all you guys. It's all your law.
What would you say?
Hypotheticals on mixed case appeals is cruel and unusual.
This happens all the time.
What I was gonna ask is, what I would like to do, if I could get your number, and I'll give you mine also, my email, and let us think about that and get back to you on it, because trying to think of this on the fly is.
I know. I agree. You have a hard job up there.
Any other questions?
But I'll exchange my email with you before you leave.
So no questions about the Sutherland case. I know that internally in the EEOC, we've certainly talked about it quite a bit. No one has a question about that? Fascinating. Apparently we're bored here, so we spend a lot of time talking about that. Any remaining questions on dual filing? This is your opportunity to pick the brains of experts at both agencies. So, if not, I want to give a round of applause to our panel. That was fantastic. Thank you very much. We appreciate it. Again, if you are registered, I'll be happy to send out Alexis's notes on dual filing. Thank you very much for coming. Please take your lunch with you as you brought it in. And if you have any suggestions for future brown bag events that you would like to see, feel free to shoot us an email. Thanks so much.